more uh, compared to the eastern part of the world. The western part, they are having more literacy in IP, and they are more aware of it. That's I think the awareness is more important rather than literacy. So this is the reason why we have selected this topic, and we thank DBT, especially Professor Rajendran sir, to give this idea and for his wholehearted support. And we are also expecting the officials of DB to join us shortly, and our principal will be joining shortly. So once again, thank you all, and thanks for your valuable time, and we welcome you for this wonderful program. Thank you. Over to Manomani.
Thank you, sir. So the session will be started by Dr. Mridul Umesh. Let me give you a brief introduction about Dr. Mridul Umesh. He is an assistant professor in the Department of Life Science, Christ University, Bangalore. He has completed his MSc, MPhil, and PhD in the Department of Microbial Biotechnology, Bharatiya University, Coimbatore, from 2013 to 2018, and he has got several research projects under various funding agencies, and also now he is handling two different research projects in Christ University under the funding of their own institute, and he has various research publications, and most of the publications which ranges from 20 to 28 publications are in essay journals, which has been indexed and has been cited very well. His area of specialization is bioplastics, biocontrol agents in agriculture biotechnology, and he has done the bioternary flushings, and he has completed several courses under WHO and in various online platforms. And he has got about 7 different book chapters which has been published in Springer and Elsevier. And he has organized about 10 to 12 webinars in past 1 year. And with this brief introduction, I request Dr. Mridul Umesh to take over the session of this IP literacy campaign.
Thank you, Manomani ma'am, and thank you, Ekata sir, for giving this opportunity. So I'm just taking 1 minute to share my slide. Can you just confirm me whether my slide is visible to you? Manomani ma'am, is it visible to you?
One second, brother.
Yes, sir, it is visible.
Yeah, okay, thank you, ma'am. Good morning to one and all who is present over here for this wonderful session. First of all, it's actually a pleasure as well as privilege to give a talk on this particular topic, which is integral component of our not only biological research, but a part and parcel that every researcher from whatever area you should know about this particular thing. And it is really a great thing that RVS is organized and the department has supported this particular endeavor. And really 4 days on the whole outlook regarding how this particular thing is important, like the intellectual property rights and intellectual property for the protection of our invention is required. That is actually the need of the hour. And once again, with a word of thanks for both the department as well as the organizers, I would like to begin with this particular session. And my presentation is going to be, as sir has told, it is regarding the overall basics of intellectual property rights, and you will have the other expertises in the upcoming days who will be briefing regarding the whole process of how to do with this particular thing. So I'm just giving you the basic outlook of how intellectual property rights is working, and what are the different forms in which you can protect your inventions, and some basic knowledge about the basic intellectual property and intellectual property protections is what we are going to see. So let us begin with a simple question. should you protect your invention? Because why this question is so much important in this particular scenario is maybe a few years back, the amount of persons who are doing a PhD research or the person who are coming into the research is very less. But now, since our knowledge is advancing and we are more and more equipping ourselves so as to march towards the new eras of technology as well as your science, the piracy or the copying of the inventions, or just copying one particular inventions as or else one particular idea, and all these things has also been increasing, because of course, since the coin has two sides, the biopiracy is also increasing. So there was this is not just about the biological part. Once we consider, let it be an engineering invention, let it be an invention which is pertaining to a product, you know that there's a lot of fake products which is coming into market. So the actual inventor is interested so as to ensure the protection of his invention as well. So there comes the need for understanding the concepts of your intellectual property rights. So what rights you as an inventor has and what you should do legally to protect your inventions. So that is what we are going to discuss in a span of another 30 minutes or so. So the basics about what are the different forms in which you can get the protection for your invention, why there is a need for your protection, okay, of this your invention as such. Okay, so basically, you as an inventor would have spent a lot of time, a lot of effort, you would have faced a lot of hurdles in inventing something. Let it be a machine, let it be an idea, let it be a product, let it be a process, whatever it may be. So it is not just happening within a span of 1 day or a 1 hour or so. It would have been taken a lot of effort, both manual effort as well as your mental preparation, as well as a lot of hurdles you would have faced so as to make this particular things to happen or to come to a reality. And easily that particular thing can be copied by some other persons, because technologically we are much more advanced. Whatever we are doing is published or in some way is available to the public. There are always chances of it being available to the public in a wrong way as such, so that you as an inventor, it is not just you should restrict yourself in inventing, but you should have the particular responsibility of protecting that thing so that it is not being exploited in a wrong way. So there comes the need for your intellectual property. And what does this IPR stands for? So IP is actually intellectual property, and IPR stands for intellectual property rights. So intellectual property is any creation of human mind, like it could be a tangible property. Their creation has a value, and as with all property, it needs to be protected. Since this particular property, or particular, which maybe as I told you, it could be a product, it could be a process, it could be an idea, it could be an artistic work, whatever it may be. So since it does has a value, there are high chances of it being exploited. So there is a need of that particular person or an inventor or an organization which has come with this particular idea or particular new domain which is novel, so as to protect them from being exploited. So that is why we require this intellectual property understandings or knowledge about this intellectual property. So intellectual property insists on some amount of novelty or originality to gain protection. So just by doing a particular research work, not all the research works or not all the research data is amenable to a patent or a copyright or any other thing. So there should be a high degree of novelty in your work so as to gain a protection for that. And intellectual property is not a lifelong thing. It is, of course, duration specific, but of course, depending upon a patent in different countries will have a particular duration. After that, you can renew it, and copyright will have a particular duration. After that, of course, you can renew it. And there are some changes in the duration depending upon the country that I'll explain once I'm moving towards the further slides. And one thing that wrongly what people used to confuse with this particular thing is, once you have an intellectual property right, IPR or a particular patent with you, it doesn't mean you have a monopoly of that particular one. See, the concept is you can always introduce that particular thing or sell that particular patent to a particular, or share that patent with a company, so that the commercialization of this particular thing could be achieved. Okay, once you're just formulating a herbal combination, or once you have a machine, design of a machine which is available, but for propagating or commercializing that, you as an individual cannot do that. So you require the support of a company for the production particular part. So you can actually collaborate with them with the intellectual property rights, which can be with the person, or it could be changed, or it could be shared with the company as well. So this is what actually meant by the last point. So moving towards this particular cartoon, I hope that most of you would have who have attended other lectures on IPR would have seen this particular cartoon, because people used to generally start with this particular cartoon because there is a twisting. It's almost like a tongue twister where too much confusion about the different domains of this particular intellectual property rights are being picturized over here. So it includes like, can I patent my copyrighted trademark? So what I would like to tell you is here three things are getting confused. So a patent is one form of IP protection, copyright is another one, and trademark is another one. So the guy is actually not knowing what to do with his invention, whether he has to patent it, copyright it, or trademark it. And this particular confusion is with the researchers or with the person who's an inventor as such. So I hope to clear that with the particular session is before the particular session is ending as such. So all we have to know is what is IP and what is IPR. As I told you, IP is all something which is related to your intellect, that is the stuff inside your head. So it should be a confidential, and it should be it should own a proprietorship as such, so that this particular thing requires some sort of your protection. And what is its importance? So this is highly important because it derives the economic benefits once you're dealing with some kind of the product as such. Wealth of a firm or a country which is developing or which is putting forward the invention, which has a certain degree of novelty, and financial return, especially in R&D sectors. Basically, of course, it supports it's only because like you have this intellectual property protection or the patenting or the particular rights with a particular country, the financial benefits, the monetary benefits on selling that product is that you're gaining, and which offers a lot of foreign exchange to you as well. Monopoly. So monopoly, all you have to you need not confuse with the terminology what I explained in the previous slide with this. Here the monopoly actually refers to even if you're selling this particular thing or commercializing that one, the ultimate right for the particular composition or the particular preparation rights relies with you. So that gives a protection towards your invention, even if you're commercializing that. So this is the importance of this particular IPR in the current scenario. And there are different forms of offering IPR protection or the intellectual protection towards your inventions. So the most common things which you will be very much aware of is the patents, copyrights. So patents and copyrights is the general things which you would have basically heard of. Apart from that thing, there are many other things as well, like trademarks, trade secrets protection, industrial designs, integrated circuits, geographical indications. So all these things could be coming under the concept of your IP, and there are certain laws and regulations and certain kind of acts which offer protection to this particular, all these particular things, and each of one will be encompassing a particular domain which will have its own clarity or its own regulations to be included under that particular form as such. So we'll see one by one quickly. So before that, why this I just added up, which in order to ensure that why there is a need of understanding about the intellectual property rights on an educational institution, especially higher education institutions like a college or university. Because you may think like why an academic or a partial academic as well as a research institute should have a proper understanding regarding this particular intellectual property rights. So it's clearly we should have a proper understanding, whether we are a teacher, whether we are a coordinator, whether we are a head of the department, or whatever it may be. Because first thing is the national IPR policy. We do have a national IPR policy which was initiated and approved at the Union Cabinet in May 2016, in which this IPR framework as well as the understanding about this IPR concepts as well as the processes should be delivered towards the entrepreneurs, the inventors, as well as the students who are doing research or who are into some kind of the ideas which can generate a startup or an entrepreneurship as such. And second one, the University Grant Commission, UGC, it has its own highlightation of this intellectual property rights. So basically, in all your bioethics, there would be some kind of paper called as bioethics, hopefully in almost all the university syllabus, or the research ethics or research methodology, in which the concepts like your IPR as well as the biopiracy or any kind of this copyright infringement, all those things will be discussed, because to deliver these concepts towards the students is a need of the hour. Apart from that thing, we are all the education institutions are concerned about this ranking status, basically like the which is issued by your NIRF, like your National Institutional Ranking Framework, and which is under your Ministry of Human Resource Development, or your MHRD. And this MHRD basically issues this ranking based upon how much research and development, basically one of the major thrust area of ranking is based upon the promotion of innovation, research and development. So once research and development is flourishing in a particular institute, the number of patents which is submitted or awarded to the university or to a particular college or an education institution or a research institution does has a certain degree of your marking. So it is not just the matter of publication, which we were doing for the in the past decades, which will be bringing glory to the institute basically on terms of ranking, but of course how much patents you have published, so how much innovations has come from your research, that does matter once the ranking is concerned. And finally, coming towards the technical education, that is your in case of your AICTE, so basically which is concerned with the engineering one, they also emphasizes the IPR education, because a lot of designs as well as a lot of engines as well as those kind of technical aspects is putting forwarded by this engineering colleges and the technical research institutes. For their protection also, they should know what is the basic things, because it is much more amenable to the piracy rather than the usual science research, technological research. A mere copying can be marketed as a new product, so that they should clearly know that how to proceed with this particular thing. So moving on to the on a world level, we have a particular organization called as this World Intellectual Property Organization, which was which was established in the year 1967, and this is under, of course, under the norms of the United Nations. And finally, this major role of this particular thing is to promote the protection of IP, the intellectual property things, and its headquarters is in Geneva, Switzerland. And in India, we will have the intellectual property rights as well as the patent guiding, as well as the head of this patent organizations, which is headed at Kolkata. And we have 4 branches, like one in Mumbai, New Delhi, and another one in Chennai, for any kind of your queries or any kind of your submissions, as well as any kind of your help for your intellectual property rights associated things, for your patenting, copyright related things, for your trademark submission and all those things. Okay, so moving to the next one is what are the types of intellectual property rights. So the property rights, it could be like various types. It could be there could be the industrial designs which can be subjected to under the intellectual property one. It can be patents, it can be trademarks, it can be trade secrets, geographical indicators, layout designs, plant varieties, and farmers' rights. This is a bit different. Like the last one, plant varieties and farmers' rights, are concerning with the generation of the hybrid varieties in certain labs, so that they can actually have a right on that particular one as such. Otherwise, usually the living organisms as well as the microorganisms, we have restrictions in getting patented for that particular things. But hybrid varieties, of course, you can go for this particular patenting aspects. Okay, so we'll quickly see one by one. Before that, this is what I told you. There is certain amendments and act which will be covering these particular things in detail, which means that the functional and technical inventions are protected by the Patent Act, which is initially put forward in the 70s and has the amendment in 1999 and 2005. Whereas the Copyright Act is something which is related to your artistic kind of the work rather than inventions. where you have certain amendments. The rule was published in this particular year, 1957, and the amendments were, there are a lot of amendments which has taken place for a betterment aspect. Symbol, logo, word, sound, color, design, all these things are something called as pertaining towards the Trademark Act, which was put forward in 1999. And the amendments was happened in, so it is actually initially it was supposed to be put forward in 1994 and 1996, but later on the combination of the Trademark Act was done in 1999, and under 2000 the amendments was taken place. Okay, so let us go to the business. That is all about what are the different forms and which are subjected towards the IP protection, or which is an intellectual property, and how you can actually protect that. The first one is an industrial design. So to make you very simple to understand, I don't want to put so much of things into your head and to confuse you. Imagine that whatever you have a car, so the car is the main utility, which has a utility. Okay, the main purpose of a car is for traveling purposes, right? So now the design of a car is a particular property of a company, because the design or the engine design as well as the basic outlook design of the Volkswagen would be different from that from the Benz. So basically what makes them, even though the both of the purposes is the same, both the cars are meant for the traveling as such, so the purpose is traveling, but of course they have their own provisions, they have their own modifications, they have their own luxurious provisions which makes the particular people to select them, and the other one will be going for the next model depending upon what the persons are actually requiring. So likewise, industrial designs could be protected because the designs will be dealing with the features, shape, pattern, etc., which is applied to an article. So the purpose of the article here, I given an example as in case of the chair, because the chair doesn't have any kind of, all the chairs are meant for sitting, but if you see the basic architecture outlook of how they have been made, that particular outlook, that design could be patented, that design could be actually protected by means of an IPR protection, which may be in the form of like a submission as an industrial design, which could be owned by a particular company. For example, if the model of a particular industrial design of a particular bike is owned by a particular company, whereas in case of the car, either the machine design as well as the outlook design is actually owned by a particular company, which cannot be copied by another company. So that is what about the first one, which is your industrial designs. So industrial designs will be coming under the aegis of your intellectual property and would be protected by intellectual property rights. The major concept which we want to understand, since we are in an academic research institutions, is about the patents. Because nowadays, this is actually like, it's a controversial thing whether it is right or wrong, because every institution, every teacher is being inclined towards publishing their works because it is mandatory for improving their profile as such. But one problem with this patenting aspect of research is, before you're publishing your work, before you're patenting your work, you're not supposed to publish either the parts of that research or a complete results pertaining to that research if you want to patent them. So that what happens, till you are awarded with a patent, you will not be able to publish any part of the research what you have done. So this will be putting a pressure towards the teacher, whether I have to go for an immediate publication because my salary, my appraisal scores and all those things will be depending upon this particular thing. But all what we have to think on a broader sense is, whatever be the research, it should serve the society. It should not rest it just with a paper, but it should be whatever research you are, whether you're a science, whether it's a technology, whether you're education, whatever it may be, it should be for the benefit of the humankind. So under that context, a patenting would be one of the particular way in which you can protect your invention so that it can be disseminated towards the public. After that, you have enough time for publishing the same thing in a research journal with quoting of this particular patent in your acknowledgement of the same journal. So that this is what is pertaining towards the patent. And patenting process, most of you are very much aware of what are the things which has to be patented and what cannot be patented. And we would have actually listened to many of these particular things where even the Indian inventions are being in the sense like turmeric and neem, all those things, the patent is with some other country. Why? Because we don't have a documentation of the usage for a very long time. Okay, so with that, this is all about Patent Act. So the Patent Act was put forward in 1970s, which will be granting the inventor a sole right about this particular invention. But there is another clause. If you're working for a particular company like a Himalaya Drugs, where you're formulating a particular Ayurvedic formulation, say a particular drug against COVID, that the researchers are doing, it will not be under the aegis of a particular person. The patent won't be under the name of a particular person. Rather, it will be under the funding company's name. So what could be the things which could be subject to a patenting? It could be either a process of development of a particular vaccine, or the vaccine as such, the product as such, or both can be patented. It can be the design of a particular process, like a downstream process, upstream process, and an electrical circuit and all those things, or the basic machine as such could be patented. Or it involves an intensive step, because it's not a one-day job, and it is again costly affair as well. Unless you have a funding partner, it is relatively costly to move for a patent as such. So it is be capable of industrial applications. Once you patent it, you have a greater reach, and there could be companies or startups who will be taking your inventions and propagating into an industrial scale or a commercial scale. And you can have if you're devising a particular instrument, say a machine, all these things can be patented, and further it could be extended towards the general public with collaboration with an industry or an industrial partner. So this I have actually even I was not aware of this particular thing till I was preparing for this presentation. So it's new to my knowledge also. There's a boy called as Hridayeshwar Singh Bhati, and he is actually a handicapped one, and he's in his wheelchairs. And this 9-year-old boy is the youngest patent holder. And what he has done is, as you can see from this particular picture, generally we play chesses like opposite. There are two persons who will be playing the chess game. This guy has actually designed a chess where simultaneously 6 players can actually play, and it is in the form of this particular one. So he is one of the youngest patent holders, and it sounds to be interesting to me. That's why I just included it over here. So what does it mean is there is no inclination towards your degree, your age, your whatever background you're from, nothing to do with this one. It is solely the novelty of your work which claims for the patent. And you can submit, even if you're amateur, you can actually, if your invention is good, you can actually submit it for the patenting. So the next one, so having finished 2 things, the next one what we are going to discuss is about the trademarks. So this trademark, all of you are very familiar with this particular trademark. So how will you say a trademark? So what is actually meant by a trademark? It can be a word, it can be a name, it can be a brand, it can be a symbol, it can be a label, etc. So once you're seeing the advertisements, like whatever slogans, what you're saying, what you're hearing, you would have noticed that that is not actually being used by another product. Basically, it should not be used by another product. Actually speaking, similar slogan should not be used by another product, but there are a lot of fake products who are manipulating the slogans and using. So those are amenable for punishment under the Trademarks Protection Act as such. So once a trademark can be registered, and we'll use a symbol called as TM. You would have seen all these things in particular products which you're buying, and this registration is valid for 7 years and renewable after expiry. So till this period, no close usage of the trademarks is possible. But you can see that there is a lot of fake products which is coming in the market, because with slight variations in the trademark, because trademark is supposed to be one of the legacy of this particular company. So these are some of the correct trademarks as well as the wrong one. So you would have seen this is about the fake products, whatever is available in the market as such. And coming towards industrial, I was telling you about the design. So what is basically happening? See, once you take a Coca-Cola bottle as such, you know that the composition of this particular thing is a trade secret. It's not a patented one. The composition of what makes Coca-Cola is a trade secret. Again, trade secret is one of the particular domain which is subjected towards your protection, IP protection, because only very few people will be knowing what they are actually composed of and what is the composition of this particular drink as such. But if you see the shape of this bottle, there are restrictions in other companies to use the same shape. So you may not have noticed this particular thing once you're going for any kind of the bakeries or once you're buying this particular thing. The design itself, if they are being protected, another company cannot actually use a particular design shape, as well as the color, the logo in which whatever they are giving, the color, as well as the slogan, the symbol, and the logo type. All these things are subjected towards your protection under the Trademark Protection Act. Okay. Yeah, some of the trademarks and services. So these are some of the common trademarks which you will be coming across, because the concept of this trademark protection is another company who may be close relative or who may be whatever it may be, they are not supposed to use this particular thing without the proper authorization of this particular company, so without the consent of this particular companies, or without the permission of this particular awarding agencies, basically as such. Okay. Yes. So the trade secrets, as I told you, trade secrets is not a one which is patented, because usually people used to teach like the composition of Coca-Cola is patented. It's not actually patented basically. So it is supposed to be a trade secret. Very good example I can tell you, the composition of your Sri Krishna sweets, Mysore Pak, for which Coimbatore is actually famous for. So the composition of that one is a trade secret of the company, because they are not revealing that thing towards their collaborators or the competitors. One, because it's actually restricted to a certain group of people. Why? Because their business properly depends upon this trade secret, and that particular trade secret can also be it can also be protected, authorized, legally could be deposited, so that they will be offering in case of any kind of any collaborative company is I mean coming with a claim that it is actually their rights. They can actually put forward a legal infringement case, and then they can actually get the rights back to them. So that is all about the trade secrets. And the next one is geographical indications. Geographical indications will be very much aware of, basically not knowing unknowingly, like this is a geographical indication, because you will be coming with a lot of products in the name of a particular place, say like Dharwad Peda, your Kanjivaram saris, Kolhapuri chappals, all these things. So because it is actually indicative of the quality of the product, because Kanjivaram, it does has its own particular, it is supposed to be a pioneer product, a product which has got a great legacy, which will be indicating its basically what is its quality. So likewise, those things, the geographical indications of a particular company can also be protected. Basically, this is an indication that it originates from a definite geographical area, which is used to identify the natural or manufactured products, basically. Okay. So, but the problem is there are a lot of things. If you're traveling to particular certain areas, there are a lot of things which will be or duplicate products or fake products which is coming in this particular label, like Sholapur Chadal, the paintings and all those things. Especially there are many sarees which is marketed in the name of Kanchipuram may not be the actual Kanchipuram sarees. But actually speaking, once a person is putting a case against the shop or the company which is marketing this particular one, they are supposed to be legally prosecuted. So those things can be done under the context of your geographical indication. So simply you cannot put something as a tea which is collected from Kerala or Tamil Nadu as a Darjeeling tea. So there should be a particular proof for that to be manufactured from a company who is collecting the tea leaves from Darjeeling. So accordingly, all these things will be coming under something called as your geographical indications. Okay. Now, copyright is almost you would have heard, because we have been seeing this thing, because CDs, once you're actually purchasing from your Sarigama Music and any other kind of company, you would have heard like this, it is their copyright, which means that you can copy them, you can actually reproduce them only with the permission of the company. Okay, so it is giving the company a full exclusive legal right, so as to give the permission to the person, so as to copyright, so as to what is this, so as to reproduce them, keeping the original rights with that particular thing. Same way with the books, whatever books which you are studying for, maybe your biotechnology background, computer science background, electronic background, everything would be copyrighted with the publisher. The copyright will be relying on the particular publisher. Same way, once you're publishing, if it is not an open access publication, the copyright is relied on this particular publisher as such, and he or she will have the particular rights with them, even though you will have a certain rights to reproduce only under their consent. They have to decide whether you are a person who is legally allowed to reproduce the work or not. And so what will be coming under the copyrights? Literary works, films, dramatic expressions, musical works, artistic works like your paintings, sound recordings, the original tracks, maybe like the original tracks of Zakir Hussain, MS Subbulakshmi, and all those things. So those things are actually copyrighted with a particular company, particular publisher who has actually recorded this particular one. Nowadays, there is a lot of dramatic performances which is taking place, and they can easily be copied by another artist. So under that context, the copyright will be relying with a particular sole original inventor, and in case if he or she has noticed some kind of copying from his particular work, they can legally move for the further processes as such. So the next one is all about the values of IP protection. So just this, whatever we have discussed is regarding the various ways of protecting your inventions as such. So it has a social perspective because it triggers, it gives you an idea like even if you're devising something, it has some kind of a protection. So with that, you can actually have this a greater thought, a greater global reach. So it gives you a new frontiers in the every field. It will be promoting the technology. You will have transfer of technology may be possible. So steps for globalized market rather than restrict to a lab, to a single company. You can have all these global help. A social perspective is there. As an inventor, you have you are granted the rights of commercialization, and this will be inspiring. Once you get an IPR protection on your name, you are inspired to go for the next level of your invention, for modifying or for bringing a better version of your invention. And benefits overall, you will have the inventorship, that is a great deal, and IP protect challenges of the competitors. So any kind of copying from the competitors is legally protected, and you can move with the modifications, or you can move with some other inventions as well. And of course, the final one, what everybody's thing is the fame in the society as well as the country. So you will have a particular, you will be a figure which will be actually known to a lot of people in an industry. So this is all what is the basic about why we have to know IP, what are the different ways in which things could be protected. And now you will have, I think you will have a close outlook of what are the fake products which is available in and around us. And if properly the company is monitoring that and putting a claim against this particular thing, all these companies who are manufacturing this particular fake products could be legally punished. So I have actually completed this particular one in a very small span of time, only just to give you, because my purpose was only just to give you a overall gist regarding what is actually IP and what are the different forms in which IP is being initiated, because the other persons will be coming in the upcoming sessions, in the upcoming days, will be briefing you how to move with the patent and how to actually how to submit this particular thing and how the protection is being initiated, and all those things will be discussed by the other persons. If there is any question specifically, I can actually answer. Otherwise, I've given my mail ID to you. So at any time, feel free to contact me. You will for sure get my reply. Okay. So thank you for the opportunity once again, and thank you, Dr. Manonmani, for inviting me, and thank you for the organizers for giving me an opportunity. If there is any questions specifically, I can answer. Otherwise, you can mail me. I'll just go for answering. So thank you once again. Thanks a million. Over to you,
Dr. Ramesh. The session is open for questions. Participants, you can ask your questions. If you have any queries, you can ask now. So, Dr. Mritul Umesh, you have given the nice presentation. I think you have provided a basic needs in IPR and patenting of the products and also process. Hope this would eventually aid the students to convert their novel ideas into a real product or process, which will help the society and save our nation.
Thank you, ma'am.
Okay. So, participants, I have given the feedback link in the chat box. Please fill out. Mritul Umesh, I have one query.
Yes, ma'am.
Have you ever come across to patent your PhD research?
Actually, like we were trying at ma'am because my patent, this one, as you told, like we are researching on bioplastics. So to make it to a patent aspect, we have to work a little more on that particular thing. And that's what I told you. Once we are a PhD scholars, the university it's a mandate for us to publish, as you will be knowing better. And that is where we get a confusion as a scholar whether to extend our work as a patentable one or to go for a publication. Since for the submission of the PhD, it was mandatory that we have to go for a publication. So we have to devise, or we have to actually design our work in such a way that this is my suggestion. You have to design your work in such a way that one part could be a totally confidential one, which you are not going to submit for a publication aspect. Whereas for the sake of your academic, I mean, submission processes or other PhD regulations, of course, you have to publish so as to submit the thesis as such. So one part can be that. For concerning my one, because I have whatever I have done as a part of that one is being published, so that I will not be able to do that one. But I'm working on the other aspect, the confidential part of the work still, so as I can extend that thing for another, hoping to extend that thing in, for a patent in another 1 year or so.
Okay. And Mritul, now you're doing biocontrol agents, I think so. Okay.
Yes, ma'am. Yes, ma'am. Yes, ma'am.
In your current affiliation, have you ever patented that?
Actually, we have isolated, and we are on the field trials of this biocontrol agents as such actually. But the problem is, like, as you know, that the organism as such cannot be patented, right? We have to have a formulation so that which could be patented. So now we were doing that field trial with the organism as such, but we have not mixed it with the matrix or prepared a formulation as such, because before that one the lockdown happened. So after this, once the things are resuming, we have to prepare that combination. We are extending that thing for the patent as well. So that's one of the project which you're working on currently, ma'am.
Okay, Mritul, and one more thing. Can you
Yeah.
please provide us some information on how to what to say, safeguard our culture in patentable form, where we have to give our culture once
You
we,
mean like the isolates actually?
yeah, the isolates, either bacterium or fungi.
Yeah. Actually, it is very difficult for us to patent a particular culture unless and until it is truly novel. Because once you see the literature, you can know that there are very little cultures which has been patented as such. But of course, you can actually have the sole rights of your culture. So once you're isolating one culture and sequencing it and getting it as novel, you can actually submit first thing. What you have to do is you can submit the sequence directly towards the NCBI. After that, it is better once after your work and you want to safeguard that culture, you're moving to some other place, maybe after 2 to 3 years you want to use the same culture. There is one option in MTCC where you can actually submit your cultures as a slant or as a lyophilase culture, and on your name, on the submitted person's name, it will be available. So you can restrict it to public usage, because there are one option in which it could be saved with them without display, without actually dispatch to the public, so that you have to pay money for that particular thing, for the maintenance as such. Otherwise, once it is freely available towards the public, the maintenance charge will be procured by the MTCC as such. So depositing in MTCC of your novel culture would be one of the great idea in protecting that particular thing, because even if somebody else is using, they have to count that this particular strain is being originally isolated by this particular person.
Okay, okay. And do you have any idea what are the patenting agents we have nearby our institute?
Yes, ma'am. Actually, there is a lot of nowadays. There is a lot of private organizations who are actually helping us for the patenting purposes as such. There are a kind of your consultancy services which is available, but they will be charging a lot of money, because they are actually intermediates who will be supporting this particular patenting one, and you will have been charged a lot for this particular thing. So better, what I prefer is every educational institutions can actually start a patenting help or the patenting this particular thing within their domain, within within their particular institutions, a patent cell, and this patent cell can actually coordinate with the patent office in the regional patent office, because we have our in the south zone, we will have an in Chennai, and if you see that most of the persons who are in that particular patent controlling organizations would be very much helpful. Actually, we had one of the last year we had one of the conferences over here where the head from that particular organization has given a wonderful talk regarding how they are extending help for works and all those things. So it is easy for you to, as an educational institution or a research institution, to coordinate with them with your IPR cell. First, you establish an IPR cell in the campus as such, and then you can coordinate with that particular thing, rather than going with a private consult agency who is helping you to get into a patent. Because of course, patent is not a matter of a private authority; it is a central one. It's a nationalized one. So that it's good always once you go through the right way.
Okay. Thank you, Mridul.
Thank you.
And another thing, Mridul,
Yeah.
is your lab, I think your PhD lab or your department, do they
Yeah.
have any patents?
Yes, actually, a guide has actually two patents, and they are actually trying for another one also. One is actually with this malanoid pigment production, that they've got a novel actinomycetes isolate which is capable of producing this malanoid pigments, and the other one is regarding the same thing, a continuation of that particular one in the industrial scale. It is actually a tie-up with a person who was working with this thing in the industry as such, and they got a novel isolate, and the production of this particular, the process, that is the production of this particular pigment from that particular strain, is actually being patented. Currently they're trying for another patent as well.
Okay, Mridul, can you tell what is the best topic which can be patented in our life science?
Ma'am, basically any kind of your therapeutic things, which if you're getting as a new one, it is always good. Like you can actually go for the patent, because for example, nowadays there's a lot of inclination towards the Ayurvedic and Siddha system of medicine, and they are actually equally given importance like the allopathic medicine, because their combination or this kind of this traditional medicine usage is restricted to a particular area, maybe like villages and all those things. If you could research on that particular thing, extend what are the molecules which is present over there and how it can be used for treating a particular disease, that is one way in which it could be patented. Second thing, like the product research, product oriented research, getting a particular product from a say a particular dye from a microorganisms or actinomycetes or a bacteria, those things can be patented. Or any kind of the enzymes which is of industrial importance, depending upon what area of interest you have, those can be actually patented. Or if you're into an engineering field, the particular design of a particular conductor, say IC chips and all those things, can be patented, depending upon what work you're doing and what is the need of the heart. Whatever it may be, whatever is the nature of your work, the important thing is the novelty of your work. That is the most important part, which makes something to be good for a patent.
Okay, Mridul. Thank you, Mridul. I think Deepak, Dr. Deepak has raised a hand to ask a question. Deepak, sir.
Thank you, ma'am. Thank you, sir, Dr. Mridul, sir. You have nicely presented this.
Thank you, sir.
And
Shamira, ma'am, you can ask a question. I think Deepak sir is having some background noises.
Good afternoon, ma'am. So it was a very wonderful session. Umesh sir really was very informative. The details he gave was even I can understand. It was in such a way. Thank you so much, sir, and thank you, Ipadas sir and his team for organizing such a great event for us. Sir, my question is, for example, if we go for a multi-drug resistance, for example, if I work on a combination of drugs, okay, sir, and if I go for any target sighting, for example, if it is about a breast cancer or some type of cancers, if I want to target it, and if I am in a position to patent it, for example, if my combination has 3 to 4 medicinal plants, how should I deal this issue, sir?
Ma'am, actually, first thing which you have to ensure is this particular combination is not reported anywhere for the treatment of the disease what you are targeting. Say it is a breast cancer. That is the first thing. Okay, then once you're submitting, if you see the, because I have not briefed you regarding the how a patent application looks like. So once you're submitting this patent, you will have to explain what is the novelty of your work and how is it different from the existing patents as well as the existing work which is there in the same field. Accordingly, they will be verifying like how much percentage of novelty is pertaining to your work, and then they will decide whether this particular thing could be awarded as a patent or not. Why? Because as I can understand your query, because these traditional medicinal combinations could be used in individual things or in some other combinations against some other diseases. But your could be a combinatorial medicine which is targeted against a particular disease. Still, that can be patented once that particular combination is found to be effective and it is in no way reported anywhere for the treatment of a particular disease what you are researching on. Still you can go for a patenting as in the usual norms. Same way as how you're applying for another product, a patent, you can just go for this particular thing.
Okay, sir. Thank you, sir. If, for example, one more question I have, sir. Like, for example, I said I was into 3 plants. For example, Siddha Cordifolia and 2 more medicinal plants. For example, if another plant, like one of the 3 selected plants were been previously patented, imagine like that. If that happens, and what will be my situation? How could I face that, sir?
But you are not going to patent the plant as such, basically,
Yeah.
but you are going to the combination, right? So you can go for a product patent. Rather than organism patent, you can go for a product patent.
In that case, even like if the plant has been like, for example, if some other person has have been patented in that particular compound, any other compound, that won't be an issue for us, no, sir?
For example, I can just brief you like a simple thing. Our turmeric is being patented, right? But there is a lot of products like face creams and all those things where you have a significant proportion of turmeric as one of the ingredient. So patenting of turmeric doesn't affect the patenting of the product as such. Same way you can just try with that.
Okay, sir. Thank you so much. Thank you, sir.
Okay.
Thank you.
Sir, Mridul sir, can I ask you the question?
Yes, Deepak sir. Yes.
Okay. Sir, you have mentioned about the natural resources, how to patent the natural resources. In case if I'm working with a new kind of microbes, I'm isolating a new kind of microbe from any background. I'm applying for the patent. Even after processing the file, do I have to maintain the viability of the culture? Do we need
yes, sir. Actually, if you want, because getting a patent for a microorganism, as you know, is a very tedious process. Because it is why this problem comes means we are not actually discovering anything new. It is existing in the environment. That particular thing we are just isolating. So that is actually the why we are just getting this much difficulty in getting a particular patent with a living organism. But still, if it is having a totally novel application, like how we have done with the Pseudomonas putida, if it is having a totally new applications, for getting the patent, you have to deposit that thing in any of the culture collection center, say MTCC or ATCC. If you're not, and then the viability of the culture has to be maintained. That particular culture viability has to be maintained.
Okay, sir. Okay. In case if I'm isolating any kind of bioactive metabolites from microbes means, what kind of should I have to follow? Is it same like another?
Same, sir. It depends upon like whether if you want to patent the process of isolation or extraction of this metabolite, that is something different. You have to apply as in case of a process patent. But if you're formulating a final product with the metabolite what you're getting, and it could be commercialized, means you have to follow the steps for a product patent. Otherwise, the basic steps are the same.
Okay, sir. So thank you, sir. And one more question.
Yes, sir.
You have mentioned about the private consultancy for getting a patent.
Yes.
So which one is best? From institution, individual application is best, or helping from?
It's always good once you go through your institution, sir. Why? Because we cannot actually ensure that how much confidentiality or how much, how much this particular protection the private companies will be giving for your work, the confidentiality of your work. But once you're going through your institution, there is always the support of the institution. If in case in the future there's some problem which is coming, means the institution can actually stand with the person so as to ensure that this particular invention is solely yours. So it is always good once you go through the inventions, through the institution directly rather than going with a private consultancy and applying for a patent. Even though sometimes a private consultancy application may be fast in processing, but I don't recommend that particular thing. There are high chances of some kind of issues which may come once you're going through a private way.
Okay, sir. Thank you. Thank you. Wonderful presentation, sir.
Thank you. Thank you, sir.
Dr. Mridul, sir, I think
Yes,
we have a question in the chat box by someone, Think Ink Writers.
yes, ma'am. Can you just tell me, like, yeah.
I think the question is, it is based on the literacy patent. Can we
Yes,
get
ma'am.
patent for compilation of poems and quotes?
We actually, for this artistic works, we actually don't have the provision of getting patent as such, but a compilation of poems as well as any kind of literary work would be subject to the copyright thing. So you'll be getting the copyright, but not the patent as such.
Okay, Mridul.
Yes, ma'am.
Thank you very much, Dr. Mridul Umesh.
Thank you for the opportunity, ma'am, for the institution as well as for the wonderful organization. And I wish all the best for the upcoming days as well, because this is wonderful opportunity as well as a wonderful endeavor from your side. Thank you so much.
Thank you, Dr. Mridul Umesh. Be safe, and hope we will meet in the next program. Thank you.
Sure. Ma'am, may I leave, ma'am?
Yeah, yes, Mridul Umesh.
Thank you so much.
And participants, I think in the feedback form, you can find the link for the next day 2, and hope that will enough for the next day session. And see you all in the next session. Thank you.